Hey everyone, this is Ben from Level Cut Law. Today we are going to talk about Order 14 Summary Judgment. What is summary judgment? Summary judgment is a court application that the plaintiff takes out when the defendant has no real defense. Or to put it another way, the defense is BS. What is a defense? Well, when you sue someone, the person suing is called a plaintiff. When he sues someone, he has to issue a court document called a writ of summons and statement of claim. The statement of claim will include allegations in paragraphs 1, 2, 3, 4, 5. After the defendant, the person getting sued, receives the writ of summons and statement of claim, if he wants to challenge the lawsuit, he has to hire a lawyer, or he can do it himself, to dispute, to explain why the facts in the statement of claim are not true. So he can say paragraph 2 is denied, paragraph 3 is not admitted, paragraph 4 is not admitted, the defendant avers that the contract was never entered into, paragraph 6 is not admitted, there was no such oral agreement. So that's a defense. Why do people take out Order 14 summary judgments? Very simple. It's to not waste the court's time over a very flimsy or flimsy defense. Not to waste the court's time going to trial when the defendant has no real defense to the claim. Let me give you some examples of no real defense, or to put it another way, BS defense. I once sued, it was a landlord-tenant dispute. They entered into a tenancy agreement for 1 year. Then he signed a renewal and subsequent tenancy agreement, and suddenly he ran away. So the landlord wanted to sue him for the damages for the remaining months. His defense was that his signature on the agreement, which was signed on every page, was superimposed and photoshopped onto the new agreement. It was copied from the first agreement that he signed and then photoshopped to the second agreement. Obviously, that is a BS defense, so I took out an Order 14. Another example of Order 14 would be bare denials. What are bare denials? Bare denials are like, if the defendant, the person getting sued, in his defense he said paragraph 3 is denied, paragraph 4 is denied, paragraph 10 is denied, all the allegations are denied, denied without providing anything. And if you have documentary evidence showing that the denials are not true, then you take out an Order 14 summary judgment. I once had another case, also a landlord-tenant case. It dealt with option to renew. The landlord and tenant had entered into 4 tenancy agreements over a period of 8 years. Each of the agreement contained an option to renew clause, unconditional option to renew clause. During the first 3 tenancy agreements, the landlord granted the option, the new term under the option to renew. For the 4th tenancy agreement, even though there was an option to renew clause, she refused to renew the option for a new term. So I sued her, I sued the landlord for breach of contract, the option to renew. And her defense was, can you believe it? The notice to exercise the option was not sent by registered post. The lawyer must have cracked his head to think of a way to get her out of this mess. So he looked through the agreement. At the very bottom, there was a clause saying, all notices shall be sufficiently served if sent by registered post to the address of the landlord or the tenant. So during the previous 3 renewals, all the renewal notices were sent by email and she accepted it. So this time, because she paid her lawyer to get her out of this mess, the lawyer had to think of something. Her sole defense was that the notice to renew was not sent by a registered post. Therefore, she's not liable. Of course, I had to take out an order 14 because it is BS. So yeah, I took an order 14 and we got damages in lieu of specific performance. Now I'm going to talk about the process for an order 14. The plaintiff, who is the one who is suing, will have to take out a summons under order 14. The summons has to be accompanied by an affidavit, a sworn statement of facts stating the reasons why a summary judgment should be granted and why a trial is not necessary. After the summons and affidavit is taken out, the defendant, the person getting sued, has 14 days to issue a reply affidavit stating to resist the order 14 application, to give reasons why there are issues or questions that ought to be tried. And after that, the plaintiff will have to issue a third and final reply affidavit to address the reasons of the defendant why the order 14 should not be granted. So after these 3 sets of affidavits have been filed, the court will, during the pre-trial conference, will give a hearing date and time for the 2 lawyers to give oral discussions. There will also be written submissions. Each lawyer will have to give written submissions, legal arguments, why order 14 should be granted. For the defendant's lawyer, he has to argue why order 14 should not be granted, why there are facts, to be decided at trial. So after hearing the order 14 application, the judge can grant summary judgment if it's a very clear case, there's no defense, the defense is BS, or the judge can give what is called unconditional leave to defend. That means you can go ahead with the lawsuit. The judge can also give conditional leave to defend, which means there will be conditions attached to it. The defendant has to pay money to the court and all that. Now, what's the cost for an order 14 application? Well, it can cost from $5,000 all the way to $15,000, $20,000 because it's very tedious. There are 3 or 4 affidavits to be filed, many pre-trial conferences, and there's written submissions. Written submissions can be up to 50 pages long. But if you win an order 14 application, under the rules of court, you're allowed to be compensated by the losing party up to $10,000. So thanks for watching this video. Don't forget to click like and subscribe.